Hello friends, in the series on income tax cases today we will discuss a case in which a very pertinent issue was before the Honorable Bombay High Court, and the issue was that if the case of the assessee is reopened under section 148 by giving the reasons that the assessee has gifted some shares and some capital gain has escaped assessment. So whether in that case the reasons suggest that the income has escaped, or whether in case of gift capital gain may arise or not. This issue has been taken up by the Honorable Bombay High Court in the case of Jet Trust versus Union of India and another, and this case is reported in 475 ITR at page number 568, and the date of the judgment is 8th March 2024. The present case relates to the assessment year 10-11. In the previous year relevant to the assessment year 10-11, the assessee has transferred the shares of a listed company to his relative by way of gift, and the assessee has filed the returned income at nil. The returned income was accepted through intimation under section 143 subsection 1. Then on 19th March 2015, the notice to the assessee was issued under section 148 by recording the reasons that the assessee has gifted some shares and the capital gain of the assessee has escaped assessment. The assessee filed the writ petition against this notice. The plea of the assessee was that in the case of the assessee, the section 45 is not applicable. The assessee pleaded that section 45 becomes applicable only in case when there is some capital asset, there is transfer of capital asset, and the assessee has received the consideration. The assessee pleaded that section 47 clause III talks about the exception to the transfer, meaning thereby that the cases which fall under section 47 clause III does not come into the definition of transfer, that is in the case of gift, will and irrevocable trust. The assessee said that since in the case of the assessee the shares has been gifted, so it comes in the exception under section 47 clause III. Since it is not a transfer, so the question of capital gain does not arise, so the reasons recorded are not correct and the assessment proceedings of the assessee should be quashed. When the court heard the matter, the court said that in the present case, the reasons itself says that the assessee has gifted the shares. So the case of the assessee comes under section 47 clause III, and there is no transfer of any capital asset in the case of the assessee. Since there is no transfer of any capital asset, so the question of capital gain does not arise. The court also said in the present case that even the section 50CA is not applicable to the assessee because that section is applicable from 1st April 2018, and section 50CA is applicable only in case of quoted shares and is applicable only when the consideration is received. Since in the present case the consideration is not at all received by the assessee, so even the section 50CA is not applicable. The court also said that in the present case even the section 50D is not applicable because section 50D is applicable from 1st April 2013, and section 50D is also applicable in those cases where the consideration is received. Since in the present case the assessee has gifted the shares, so the assessee has not received any consideration, so either of the section, that is section 50CA and section 50D, not applicable on the assessee. Friends, this case is very important because in the present case the reasons itself were saying that the capital gain has escaped assessment, and the reasons itself were suggesting that the assessee has gifted the shares. Once the assessee has gifted the shares, then it is not a transfer. When there is no transfer, there is no capital gain. So sometimes we get the clue from the reasons that the reasons are recorded are not applicable to the assessee, whether in law or whether on facts. So in the present case, the section 148 proceedings were quashed by the Honorable Bombay High Court. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Jet Trust versus Union of India and another, and this case is reported in 475 ITR at page number 568, and the date of the judgment is 8th March 2024.